Hello friends, Namaskaram, how are you? Myself is Dr. Jineesh Soni. I am an advocate and a defense counsel. Har Har Mahadev, Jai Shiv Shambhu. In today's class, we are going to discuss an important judgment of Honorable Karnataka High Court which is dated 26th of Feb 2026. In that case, the accused had been charged as per Section 7 of Prevention of Corruption Act. Ultimately, he has been acquitted, but state has filed an appeal before Honorable High Court. An appeal has been dismissed. So I have observed the entire judgment, but to assist you more effectively, I am going to differentiate the topic in two parts. Number one, the negative traits, it is concerned with the prosecution, and positive traits, it is concerned with defense theory. So, whenever we contest our case, there might be a negative or positive trait. So, basically, in which manner we have to consider our case or observe our case so that we could be succeeded. In that scenario, we must be acquainted with the negative and positive traits. So basically, whenever the case of prosecution is put up on record by the way of charge sheet, the prosecution might submit their demand is proved. Regarding this, the prosecution might rely on the report, transcription, the verification report. But I want to clarify that every demand of money is not demand of bribe. The prosecution has to prove that there is a work pending with the accused, and to do that work, the accused had demanded the bribe. If the basic elements are not on the record, means the motive is not present, there is nothing on record to show that there is any pendency of work. In that scenario, the accused could have the benefit. So demand is must. If demand is not proved, demand is not stand, in that scenario, the accused could have the benefit. I want to clarify that. Mere acceptance, mere recovery cannot be a basis for the prosecution. And apart from that, the prosecution might rely on the voice recording, transcription, FSL, sanction, and charge sheet. So basically, these documents are going to constitute the incrimination against the accused, and that's why I considered it as a negative trait. So if you want to have the positive effects in your case, just observe all these things. Regarding this, at the inception, you may submit the memorandum, which you usually avoid. You think that by doing the same, your defense might be opened or the prosecution could work out on the same. But can we think our case in a different way? For example, if no work is pending and the material fact has not been verified by the ACB, and you want to chalk out a case for the unfair investigation, what you can do? By giving a simple averment or assertions, you could not be succeeded. But with the help of memorandum, we could be succeeded. I want to emphasize on the instance. No work is pending, but this fact has not been verified by the CBI or ACB. But in the memorandum, you submitted that no work is pending, sir. Please verify it. But despite of submission, they failed to verify. In that scenario, it could be clear that they are affected by confirmation bias. Means they consider you as an accused and ultimately collect the evidence so that you could be prosecuted. Agency is not required or expected to do the investigation in favor of prosecution. The investigation is for both, for the prosecution and for the defense. If the material facts are supplied by you and the concerned agency never considered it, in that scenario, we could chalk out a good case for unfair investigation. The said principle had been recognized by Honorable High Court in that case as well. Now I am coming on the positive traits. Basically, we have to observe when the concerned complainant had communicated with the accused for the first time. If there is a delay in the report, means he has communicated, and there might be a case that at the time the accused demanded, and after a very long time the report has been lost, then we could have the benefit. Because as per the protocol of Section 8 of the Prevention of Corruption Act, the report must be lost within 7 days from cause of action. If it is not happened in that scenario, we could have the benefit by the virtue of Section 119 subclause G of the Bharatiya Saksha Adhiniyam. And apart from that, if the concerned complainant submits that there is a negotiation or round of negotiation, but there is nothing regarding the same in the transcription, and apart from that, work is not pending, the work has been done prior to the proceeding, and the concerned complainant or other witnesses are going to improvise in their testimony, the testimonies are inconsistent, there is lack of corroboration, and electronic evidences are not produced as per the protocol of Section 65B of the Evidence Act or Section 63 of the Bharatiya Saksha Adhiniyam, in that scenario, we could have the benefit. So basically, we have to observe the entire scenario. If the scenarios are not going to corroborate, the scenarios are inconsistent, and apart from that, the investigation is unfair and sanction is sacrosanct, and apart from that, there is no compliance of judgment of Honorable Supreme Court, that is CBI versus Ashok Kumar Agarwal, judgment date is 31st of October 2013, then we could have the benefit. So we have to scrutinize our case in light of the legal position observed and laid down by Honorable High Court and by Honorable Supreme Court, so that we could effectively put up the plausible effect in our case, because we are not required and it is not expected from us to prove our defense beyond reasonable doubt. It is expected from the prosecution to prove the case beyond reasonable doubt. So if our defense is probabilizing, and apart from that there is inconsistency, there is lack of corroboration, then definitely we could have the benefit. So just observe your case if you really want to succeed, because by relying on the advocate you could fight but you could not be succeeded. You have to observe your own case, you have to find out the errors, the omissions, the inconsistency in your case, and then with the help of expert you could review your case as well, so that in the light of law, in the light of factual score, in the light of inconsistency, in the light of non-compliances, you could have the plausible defense on record. If your defense is plausible and it is duly supported from factual perspective, from legal perspective, then definitely you could have the benefit. So there is nothing to worry. Just work out, just open your file, read out it, and find out the scenarios which I specified to you. See you in the next lecture. Till then, Har Har Mahadev, Jai Shiv Shambhu.